You'll sit it out in the county jail until we can dispose of this case. If anyone on your behalf tries to contact this person, which I know happens too often, because people get into trouble and then they start trying to figure out how to absolve themselves of trouble, and they do it the wrong way. The law states, and the rules of this court state, you cannot approach or have any contact with a victim, even if they're a relative. And it would even be a fact if it was your parent that you had shot. But a cousin, still, you cannot. And if I find out about it, because the state's always looking into that, they want to make sure that people are safe. Because too often in this court, people think that they can manipulate the law. When they do that, they get in more trouble with me. If I find out you had any contact with this person or anyone on your behalf, it'll be this quick. You're going to jail until we can figure the resolvement of this, which could take years.
We've been over that a couple of times.
Yeah, I know. And the lawyers advise them, and still it happens over and over again. And those people are sitting in jail waiting for trials for years sometimes. And that's what happens if you don't follow the rules. Is that clear?
Yes, sir.
And I'm going to ask the state to make sure, if you'd be so kind, check on the victim, make sure that there's been no contact.
Yes, sir.
Because the moment I want to know, a warrant will be for your arrest. That crystal clear. You're looking at life imprisonment, sir. Do you understand the importance of this? How old are you right now? Yeah. Life, that's the rest of your life in a cell. Well, that's what happens when you shoot people. Usually relatives. If you're going to treat a relative like this, what are you going to do to a stranger who you take a disliking to?
That's the 822 minutes back. So I think you're
Well, there's surveillance footage of this. Did you get that?
I have the discovery.
You have, okay.
It's just a very serious offense and we're handling it. And
I just want to make sure there was this, it looks like a video here that's out there that you certainly don't want to miss. What was the significance of the injury here?
He was shot in the chest. I'm not sure.
Really? I mean, that's lethal, isn't
Not my
it?
case.
Generally.
Yes, sir.
Oh,
believe me, I have.
I didn't hear what you're saying.
I believe he had a wound to his abdomen and an issue with his liver resulting from that.
The liver?
The liver.
That can be lethal.
That's why the serious.
Okay, and yeah, gunshot injuries to the liver and the stomach. One increases a punishment range.
Was charged with nothing.
Yeah, it's still family anyway. This aggravated assault, which would have been a second-degree felony, is actually indicted as a first-degree felony because when you assault a family member, that increases the exposure to responsibility for a crime. And the theory there is, if you're going to treat family members badly, what are you going to do to a person who's a stranger? That's the spirit behind that law. But anyway, you're looking at a first degree felony. If convicted of this, you're looking at no less than 5 years imprisonment to life imprisonment. And because this is a firearm, a deadly weapon that was used, if you're convicted and sentenced to prison, you won't be parolable until you serve at least 50% of your time, which is a long time. What are we going to do today?
Judge, I've just got an updated offer for Mr. Coleman. He was just assigned the case. I'm hoping to talk to him about that, see if he's in trial next door.
Huh?
They are in trial next door, but
When's he
I
going to start coming over here? Next week?
Yes,
Oh.
they just had to finish the trial.
if I could have a one more 4-week reset to figure out what direction we're going, I need to be able to sit down and talk to Mr. Coleman.
This, in this case, Mr. Guidry, I don't know if this is a relative of yours, but under the law, whether it's blood relation or not, when you're accused of a crime like this, a serious felony offense, you cannot have any contact with that person. Do you understand? And if you are, your bond, if I find out about it, your bond will be revoked. And I know people who have been shot in the stomach before.
Judge, we're working on.
Try to digest your food for the rest of your life with that. Okay, next event,
4 weeks, Judge Brandon.
done.
Thank you.
You're still here?
Yes,
Zariah? Here?
Breaking day.
it is right okay.
Well, hopefully Reagan can resolve some stuff today. too.
Loads a lot of initiatives today.
That means, like,
At once.
when we kick the can down the road day. 26 CRA 33 is called. Can you pronounce your first name?
Zoe.
This is.
Zoe area.
Everybody's started at once. Go to me. What is it?
Zoe area.
Okay, Zoe area. Okay, I had never heard of that one before. Is it a family name?
It's funny.
I mean, was it like an aunt or someone that you, okay, where's it taken from? I knew your mom, God bless you. But I mean, how did she come up with that name? Because I've never heard of that one before. Where'd you come up with that? It's part of your name? I'll be, yeah, that's unique. All right, all that aside, now serious stuff here. You're charged with theft. But see, the problem you have is that according to this indictment, you have 2 or more prior theft convictions. It looks like you had 3 convictions on one day, April 29th of 2022, out of the County Court at Law 3 of Jefferson County, Texas. When you have 2 or more theft convictions, if you steal a pack of gum, it's a felony for the rest of your life. I don't know what you're stealing, but it says personal, marked from Market Basket, and it was less than $2,500. If it was a penny, if it was worth a penny, it's a felony. I mean, that's important. You're supposed to live honestly. Thou shalt not steal, that's in the commandments and all, and in the law. So but you went through these 3 cases, and certainly it was impressed upon you the importance. You had to go in front of a judge, and I don't know what happened on the disposition, but you were convicted of these. You may have paid a fine. I don't know if you might have even gone to jail, which is not what you want to do. But here you're looking at up to 2 years in the state jail. And this is not a misdemeanor. This is a felony, which follows you if convicted the rest of your life. Try to get a job that you want when you've got a felony conviction. Good luck. People don't hire folks like that, especially if it's theft related. They go, well, if they're going to steal from others, why hire her? Before we know it, she'll steal all our stuff. That's what people think. That's why you have to live honestly. Okay. From here on, do that, okay? All right. Fine. Oh, anyways, what are we gonna do today?
Judge, this is an initial setting. I need to talk with her about the discovery and everything else. If I can have a 4-week reset. I have received an offer. I just have not had this is my first encounter with her, so I need time to go through everything with her.
Don't steal. Again, a penny of something worth a penny is still a felony for you for the rest of your life. That ought to help you be honest and do the right thing. No one, trust me, you don't want to go to prison. And that's where this goes. It's a prison facility, type facility. Fix this. Live honestly. Get a resetting. Daryl Jones. That's you. Where's Daryl Jones?
Trying to make his way up here.
Yeah, you, whatever way you can get here.
I'm sorry.
Okay. In 26 CR 638, you are Daryl Dwayne Jones, correct?
Yes, sir.
You're here with Ms. Minaldi, your attorney and the state's attorney. Probably intimately familiar with this indictment that's charging you with a 3rd-degree felony of tampering with physical evidence. If convicted of a 3rd-degree felony, you face no less than more than 10 years confinement in prison, and a fine up to $10,000 can be assessed.
See what plan in there.
This has got a prior conviction, but it looks like it's a misdemeanor of drugs, illegal possession of controlled substance out of County Court of Law 2. I don't see another felony. Due to being a felon, possessing a bottle. Did you see this probably call something? You always do. I'm not talking to you. I'm sorry. Yeah. Why are they talking about, what's this about? In this, are they just wrong? They must be wrong because they keep talking about him being a felon due to Jones leaving the scene of a firearm with intent to impair its as evidence and being a felon possessing a firearm at a location in which he does not live. He was charged with unlawful possession of a firearm by a felon and tampering. I guess that were they mistaken, you think?
Well, the system did show that it was felony.
You got a misdemeanor, right?
Yes.
Okay.
The end result was a felony was disposed of via misdemeanor plea. And that's what caused the confusion with the police.
Yes.
They always verify that when they actually charge the offense of unlawful possession of a firearm by a felon. The more serious matter is the fact that what he's charged with here, Joe.
Well, that's well and good, but I think it's a serious matter in a probable cause affidavit to make statements that aren't accurate.
At the time it was made, it was accurate.
He was a felon?
No,
Their system showed that he was convicted of a felony offense of
How does that
possession of
happen? How does that happen? Was that misstatements put into the computer or something?
I think they didn't dig far enough into the system, Judge. I don't believe they made a false statement, Your Honor. It turns out to not be accurate, but I believe that what they were looking at gave them false information.
No, so that's my question is why is that false information
Misdemeanor
in the day?
conviction from a lesser included plea is what my understanding is.
That's what it's showing, Judge, and I can,
System might register still as it being a felony, however, it was not resolved as a felony conviction, it was resolved as a lesser included misdemeanor conviction.
Mr. Jones was arrested on December 28, 2016 for the felony third-degree offense of possession of a controlled substance. That is what their system showed, is that he was convicted of that matter. But it's when they dug a little further, it shows it on September 25th of 2017. It resulted in a 5-day confinement in Jefferson County Jail, which has to have been some misdemeanor disposition.
Well, the system is clearing up the fact that he doesn't have a prior conviction.
I would hope so too.
Because that's what they're relying on, is that data.
It's hard to make. So.
Isn't a mistake I want to make. Oh, so you're looking at up to 10 years in prison. But at the end of the day, that's still serious. What today?
Judge, it is an initial setting. I need time to go through his discovery with him and him to get in contact with my office. So if I could have 4 weeks to do.
You got it. Okay, Antonio Landrios. All of these,
Yes.
It's been, it's advertisements and goes, it's in one thing, it's got to. So it's just on the videos. If you-
25 CR 1671, you are Antonio Landria.
Yes.
Yes. You're here with Ms. Malva, your attorney and the state's attorney. Yes. You know, I think you've been here before.
Yeah. Just you're swearing that everything we've written is true. And then obviously.
Since I'm looking at 4 different resettings already for the announcement document. You're charged with the 3rd-degree felony of harassment on a public servant. What are we doing today?
Judge, I need one more 4-week reset. He has got to come in and look at his videos and I.
Said it, we're gonna, no. We've been. No, hold on, let's take it easy. No, right.
Especially. I thought you were going to be. Yes, I did.
You have a drug patch too?
I put hands on my tongue.
You mumbled. I didn't hear what you just said. Sir?
Yeah, put hands on my tongue.
He should have a drug patch, Judge, of some kind, because when he was last in court, he tested positive for methamphetamine and cocaine on April 2nd. That means that we
I think
missed,
that was,
missed that because
I think we missed on that one. There should have been a drug patch probably, not a GPS. I don't know why that was.
Okay. Thank my tongue.
I'm sure you're mumbling. You have to.
I said they wanted to put the drug patch on, but you told them to put an ankle monitor on.
Yeah, I don't know why. Okay, tell me that again.
Without pointing out, they said you put an ankle monitor. They was about to put the drug patch, but it said put an ankle monitor on it.
Yeah, that didn't make any,
Judge,
I don't know why that happened.
I had one that I would.
Because that's apples and oranges. You should have had a drug patch. That's what I've only done for 19 years and stuff like this.
That's.
Something
all.
weird happened here.
We can get them switched out, Judge, if you want to switch.
No, we're gonna test him right now to make sure he's okay. I'm sorry, what do you say?
he's saying this.
Yeah, well, we're gonna still test you because you tested positive before. You know, make sure you're making the right choices. Okay, so we go from April 2nd to April 9th.
Yes.
An announcement there, to May 11th to May 14th. So that's been 4. Then it's June 1st. And then now today. So this is like this 5th announcement date. So what are we doing today?
Judge, this is the second day that we have approached on for an announcement.
No, I have 5 announcement settings here. Here, look out.
I believe
Yeah,
it.
don't. I want you to.
Sometime, I believe something goes, we canceled docket and I had to reset them. I'm pretty sure. And it looks like the memo that was done.
We canceled them.
I was unaware that you were in a seminar. And
No,
5 times?
No, I said 2 times, I think. There were 2 different ones. It looks like the memo from April 2nd that was
Okay,
done.
he was indicted in November.
I understand. George.
Okay, and
And-
it's now 8 months have gone by, and what are we gonna do today?
I need 3 weeks for him to look at his videos. I need him to come into the office and do that.
Right.
No, Antonio.
Reset it for 3 weeks and sit over there. I will give you this. Alejandro Sanchez. Explain those things.
Every time I thought that she's done. Straight up, actually, I think she did that.
Alejandro Sanchez, is that you? You're charged with state F felony of, looks like solicitation for prostitution, which carries with it up to 2 years in a state jail.
Uh-huh.
Yeah.
It's harassment.
You're still living in Houston, Texas? Why were you here?
I was working, well, I'm still working here at the Exxon.
Doing what?
Scaffolding.
I'm sorry, scaffolding? What are you getting paid per hour on that?
Right now it's 25.
All right. Are you retained?
No, Judge, he has filled out a new affidavit of indigency. It has not.
Yeah, you're gonna pay for your lawyer.
It has not gone to Ellie
I mean,
yet.
you're making over $50,000. You're not indigent. Okay, we gotta fix that. The taxpayers aren't gonna pay for your situation when you're able to pay. Do you understand, sir? Okay, that's what we all have to do. Pay for our costs. You have costs. The taxpayers are doing it. That's not fair to them. So what do we need to do
I
about
just
that?
got him on a designation docket in a
Now,
couple
what do
of
we
weeks.
need to do about transferring him out of indigency to getting him a new lawyer?
Judge, I think he has to have time to contact attorneys to retain one.
Yeah,
Well,
I don't expect him
Ellie
to pick up the
corrected me
phone
if
right this
I
moment.
think that looks like putting him on a designation docket in a couple of
To
weeks.
designation, he'll do the
And then-
indigent form, we can deny Reagan on it, and remove her from the system. Then he can.
Yeah, you're gonna have to hire your own lawyer, and which is, when we make a mess, we have to fix it ourselves, and that's being responsible. And the taxpayers aren't gonna pay when you're able to pay. That's not fair to them. So you've got 4 weeks. I'm gonna give you 4 weeks to talk to some lawyers about hiring them. You can even hire her. She handles cases that aren't part of her indigency representation. But that would be between you and her. But you got 4 weeks, and you're gonna get a resetting. Make sure that whoever you may hire, they know about that resetting that you're about to sign, okay? Reset 4 weeks. Thank you.
Thank you.
Bridget Webber.
Judge,
She is what?
she had a new information filed on her to resolve the felony. This is one that we tried to do on Monday. It was gonna be a lesser included, but now it's just misdemeanors. I have to go down the hall and plead her misdemeanors. And then I'm under the impression that the felony is gonna be dismissed as a result of that.
Well, I don't know who
Tommy Coleman is the prosecutor.
can we get Mr. Coleman in here
He's in trial next year, Judge.
right now?
Do you have
Do y'all know anything about this?
the possession in a correctional facility that Tommy was trying to plead down?
Yes, it's been filed down in this,
It's been filed.
it's been filed, it's ready to go this morning, so.
Yeah, I'm gonna hop down there and do those, but the
Okay.
felony's being dismissed.
Yes,
Okay, so the felony would be a
So
dismissal.
this case, well, this case has been changed to a Class B misdemeanor.
That's correct.
Correct.
Okay, what felony are you talking about?
She did have a felony of possession of a substance in a
In whose
conventional-
court is that?
It was in yours, Judge. We tried to handle it Monday.
It's right there. That's it.
Okay, okay,
That's
so
it.
it's this
It's
case.
this.
Right. We were doing a lesser included. That's why you wrote Class B on there. We were going to try to do a lesser and it's not a lesser included. So we had to refile it down the hall. So we'll dismiss that as soon as they plead down the hall.
All right, then I need some whiteout
No,
because
she didn't. She stayed.
I changed this to
Couldn't because of the.
Right,
I
so
changed this to a Class B misdemeanor, and it's not gonna be changed, it's going to be dismissed.
so she's, yeah, they're trying to dismiss this. So right here.
Let me know.
If you put a
I
nice.
need a whiteout from anybody. Do you have one?
I do not, Judge. Oh.
Here you go, Dave.
Look,
Okay, that's whiteout.
No.
Oh, you got the liquid kind.
Yeah, he likes liquid only.
Got a little left on your nose there, dude.
Yeah, killer.
I'm trying to do. Slowly. By the way, John Dixon's moving up really fast because my witnesses for pro se are on a cruise. No, you were going to resolve him. I was not sure. No, you were the sitting person.
Thank you.
You needed to, I'm saying for you, I gotta do very fine. Just, it's.
Yeah.
So just because you're standing close to me doesn't mean we're close to resolving something. Okay.
Just don't.
He's asking, it says. You know what the is.
We'll leave it high today.
Well, they 7-9, right?
Yes.
What'd you say?
I think. It's still. So.
Yeah.
Okay, so I've corrected the corrected to the correct status as of this moment. But this is to be dismissed.
The felonies.
That's correct, Your Honor.
And then I have one more, Judge, Matthew Graham. We had passed him earlier because he was in traffic here. A little more to your right.
Yeah, but he was in traffic.
Yes, Judge.
So we passed
We
him.
held him.
Yeah, and so he was in traffic, so he passed the other traffic to get here, I guess. Passed through the traffic. Passed the other
That's
traffic.
correct.
And so this is a lot of, we're doing a lot of passing. Where is it? You're Matthew Graham, and are you still at 5342? Yes, sir. Okay. So, Ms. Minaldi is here. This is an announcement. You know what you're charged with.
Yes, Your Honor.
I think we went over this because there were some things we had corrected on, and you're no longer at 4215, right?
Correct, Your Honor.
Correct. I'm gonna mark through that.
That's my Baltimore address.
The new one. Jeez.
So now, so.
I think we went over what this was all about and also the punishment range applicable, which is up to 10 years in prison. Or a stalking case, and also, let's see.
That's good.
It's children. First week of August.
We were just trying to figure out which defense attorneys are doing.
All right, you understand you cannot have any contact with this person
Yes, right.
who is the subject of the alleged victimization in this case.
Yes, Your Honor.
That would be catastrophic,
Yes, Your Honor.
nor anyone in your behalf.
Yes, no.
What today?
Judge, I was retained on this about a month ago. I sat down and talked with Mike about the case yesterday. It was Ms. Gasper's case before she left, so I'm just trying to get a handle on kind of what we're looking at, but I believe Mike and I might be close to a different type of resolution. There's a couple things that he asked me to do.
You're close to a different resolution.
Well, there was an offer in the case, but we sat down and talked about the facts of the case.
I'm gonna speak to the
Okay,
complainant.
well, I'm sorry, I misunderstood. A resolution different
Than
than what had
previously.
originally been proffered,
Yes,
maybe.
yes.
All right, so what do you want to do today?
If I could have a week reset to accomplish that, that would,
Be talking to the complainant, and I may be in trial next week, so we may be in trial.
we
next week.
may.
In what court?
In here.
Here, Judge. Aren't you excited? See,
Y'all are. I thought I used to be allowed to determine.
No,
which trial I was
we,
gonna go
we,
with, but
we took a vote. You're no longer the.
this is.
You only invite me to the meeting? I mean, I can't even be a spectator?
No, we even voted whether you could come to the meeting or not, and it was, you were rolled out.
Serious case. Have you ever been in criminal trouble before, sir?
Not of this magnitude, no, sir.
Is that yes? I'm talking about, have you ever been convicted of a felony offense?
No, sir.
All right, fix this. It's fixable.
We're working on it, Judge.
Heed her advice. That would be wise.
Thank you, Judge. That's all I have.
Marcus Amanez. Mr. Amanez is where? There? Yes. It's 4 weekday.
He's trying to kill me. Mr. Laird. I'm sorry, I'm not. But never mind. I think it's gonna be the.
Don't worry with him. What do you want to do?
Well, I mean, I've already, if I had known that, I just say dismiss it, but.
Seriously, you are Marcus Jimenez? You speak fluent English, sir?
Yes, sir.
Okay. You're here, Mr. Parker, very fine lawyer, is here, and the state, we've been through this before, I believe, because I've seen some resettings. And as you know, you are charged with a third-degree felony of evading arrest or detention with a motor vehicle. A third-degree felony carries with it
It's a plea, Judge.
up to 10 years in prison. Do you understand? Serious case.
Yes.
And we're disposing of it today?
Yes.
Well, then we're going to talk about it. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about February 12th, 2026 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? Yeah, Antonio, you're clear. You know that. You can go. Keep up the good work on that.
Yes, sir.
though. All right, thank you. You understand what you're charged with, sir?
Yes.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fine $500, and there would be terms and conditions of probation, which are normal and customary, and also particular for the circumstances of this case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
Now, we call this deferred or unadjudicated probation. Have you ever been in trouble before?
No, sir.
All right. And I know Mr. Parker has told you deferred or unadjudicated probation means you would not be found guilty so long as you followed the terms and conditions of probation.
Right.
If you failed, that happens from time to time here. Your probation could be revoked. You could then be found guilty. You wouldn't have a jury trial. It would be in front of the judge. And then you could be assessed the full range of punishment, no less than 2 nor more than 10 years confined in prison. That's why it's important to follow the terms and conditions of probation that you're going to be seeing here in a minute. If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty of what the indictment alleges here?
Yes.
Going to show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes.
Discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
We waived that, Judge.
What are we
We
gonna do?
made a suggestion on the plea papers of 5 years deferred.
I
Yes.
saw that.
And,
I have no objection, Judge. I talked about it.
Is that okay with you if we reduce the
Okay.
term of probation from
Yes, sir.
what we normally would do 10 years to half that to
That'd be
finally
greatly appreciated.
fix this? We also shorten probation by doing well to a third, which in your case, if I do 5 years, you're looking at 1 2/3 year. If nothing further, here's what I'm going to make the findings as follows. That you, Mr. Jimenez, are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. But I'm going to defer and postpone any finding of guilt so long as you follow the terms and conditions of probation here that I'm about to order and sign. There are 35 different terms and conditions of probation. The overwhelming majority of these requirements are what Mr. Parker has to do and what I have to do and what the state has to do, beginning with commit no offense. Avoid injurious habits. Don't associate with disreputable people. Certainly, this can't be hard for you to follow. I mean, these are things we have to do for the most part. There are other conditions that are specific, but when people say 35 conditions, my God, and actually, there are far more conditions and requirements that you and I are required to follow and that we do follow because it's what's lawful and proper and courteous in dealing with others. So don't get shocked. There is one other thing. He's going to have to. I want a defensive driving or something
Yes, sir.
here that he has to pass and take and pass. And I'm doing you a favor because your insurance is about to go up if it hasn't already. Your automobile insurance will go up for this. But on the other side of the coin, you take it and it will balance back out. And it's always a good thing. Okay, I've signed those. and you are going to be placed on probation for 5 years. You're getting a break, make the most of it,
Yes.
fix this and do better. Also, you're fined $500. All right, I think everything
Thank
is
you,
set.
Judge.
Please see the probation officer.
Thank you for your time.
Thank you, Mike.
Yeah.
Just showers.
Kaya, Castillo,
I'm gonna need a. She's ready. Should be on the list. Oh. You stay the same with them.
Didn't think of that one, you should have that.
she needs to go over here.
Yeah.
I'm having fun. How about you?
Thank you.
And we now call cause number 24 CR 1885, the state of Texas versus Kataya. Is it Llanos Castillo? Okay.
Yes.
That is you. It's Debbie. Do you speak English fluently?
I understand the majority of it, but not all of it.
Are you a citizen of the United States?
No,
Are you becoming a citizen of the United States? Are you in the process?
no.
No. Good. Okay. Okay, I have Miss Birch here, who is going to be the translator because she speaks fluent English and Spanish and probably 10 other languages because she's a really smart lady. And she's going to help you understand what's going on. I will be speaking English and these gentlemen will be speaking English. It will be translated into Spanish, the language you understand best. Your answers will be translated by Miss Burge from Spanish to English so all of us and the court reporter can understand what you are stating. Do you understand?
Yes.
And Ms. Burge, please raise your right hand. Do you solemnly swear or affirm? God bless you. Good trick. It does look right when you're on the YouTube. Do you solemnly swear or affirm that you will well and truly translate from Spanish to English, Spanish being the language that the defendant understands to English, so all of us here involved in this case who don't speak Spanish and the court reporter can understand. And then you will interpret Spanish not only to English, but English to Spanish so that the defendant can understand the English that is being spoken and addressed to her. And you will do that accurately. So help you God.
Yes, Judge.
Over your head. Thank you. And thanks for doing this as you always do so well.
Yes, Judge.
Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
Hold on for just 1 second. Let me. This indictment is carrying with it
There's an attachment.
it's what's petitioner supporting affidavit, which I guess is the substance of the alleged perjurious
That's correct.
statements.
That's correct, John.
All right. The defendant is charged in this case with the 3rd-degree felony of aggravated perjury. In summary, this indictment, wow, which was handed up by the grand jury on September 11th, 2024. That's old. I'm glad we're finally getting this thing disposed of here.
Yeah.
This states in the indictment that on or about March 27th, 2024, in Jefferson County, Texas, you, Pitaya Llanos Castillo, with intent to deceive and with knowledge of the statement's meaning, you swore to the truth of a false statement. And that statement is what's referred to as the petitioner's supporting affidavit that states that you, Pitaya Llanos Castillo, as petitioner in a court here in Jefferson County, Texas, a district court, in a matter concerning the interests of children whose initials are ES and AS, that in that affidavit that you swore was true and correct, you stated that you were the petitioner in the case. You have an agreement in place with your children's father, Laureano Sola Gomez, that he would have visitation every Sunday from approximately 8:30 a.m. to 9:00 p.m. on that same day. And on January 28th, 2024, you drop your children at his residence as you do every Sunday. We had decided that my son, according to this affidavit, that you signed, we have decided that my son, Emilio Sola, would stay with his father for the night because he did not have school the next day. And I was to pick up Alani Soloj, or Solo. How do you pronounce Soloj in Spanish? Is the J silent? Solojo, like an H. It's an H sound. Okay. To take her to school the next morning. You went on in your affidavit to state that he initially told me he was going to take the children to a party. I went to pick the kids up from their father, and they were not at his residence. When I got there, I called multiple times. Laureano Gomez finally answered the phone and told me he was having the kids checked out in the hospital, claiming I had abused the children. I have never abused my children. I was able to get my daughter from him and take her to school. And this statement goes on further, which ends with the only time since he had taken the children away from me that I was able to talk to them or see them was this day on February 16th, 2024. So what this apparently boils down to was a statement you made, an affidavit under oath dealing with your relationship of the children and visitation and possession of the children with your husband or ex-husband. I don't know, the father, the children's father. And apparently, according to this indictment, this statement, this affidavit that you signed under oath contained false statements or a statement regarding Laureano Gomez forcibly taking the children away and not allowing visits. And that was a false statement that you made. And that affected the custody relationship of the children, which was being handled out of the 317th District Court of Jefferson County, Texas. Do you understand what you were charged with in this indictment?
Yes.
If convicted, this is a third-degree felony, and you are facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand the seriousness of this case in regards to the punishment that can be assessed?
Yes.
An agreement has been reached that you would be pleading guilty, not found guilty, but placed on deferred or unadjudicated probation. And this can be up to 10 years in length. I don't see a fine. There is no fine here.
No fine, Judge.
Is this your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this charge, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Understand it?
Yes.
Discuss it with your attorney? And are the contents all true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you guys.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Please, Your Honor.
Okay. What are we saying about the length of time, State?
I don't have any objection, Judge. She has no priors. This was a matter involving custody issues and a divorce, so I think things got carried away.
Do you understand this seriousness of all of this matter?
Yes.
Are you certain?
Seguro que sí entiendo. Yes.
Okay. What has happened here by not being honest
No ser honesta
and truthful,
y decir la verdad.
you have put yourself in a difficult position in this arrangement with the children and your ex-husband in this divorce case. Number one. Number two, you're not a citizen of the United States. And this can affect your ability to become a citizen. Number three, this is aggravated perjury. Aggravated perjury may be one of the most serious crimes, because if you're convicted, you are represented as a liar the rest of your life. Nobody wants that. You understand how important it is to be honest. In your case, it affects you in several serious ways. That's what we all should live honestly. But you have a lot to lose by not being a citizen. Immigration and customs could do something about that if they want, because this is a felony offense. You're not found guilty, but you pleaded guilty to it. Also, it's not going to help you in the divorce case and getting privileged visitation with the children, because judges need to be able to trust the people who are before them when the judge makes orders. You have to follow the order. And also, once again, perjury, it's, it stamps you as somebody dishonest publicly. That's terrible. You don't want that. But you know, right from wrong, truth versus lie, live honestly. You have a lot at stake, as we all do, but you especially, as you, it can affect your citizenship here in the United States, among other things, and the relationship you're going to have with your children during this divorce. Fix this. Oh, there's only three things people have to know. Live honestly. Harm no one. Give each person due respect. Three things. All law is based upon one, two, or all three of those. So you don't have to memorize all this. It's only three things. We can boil it down to three things. And these three are all part of what you're involved with right now. Okay, fix it. If nothing further, I'm going to find as follows, that there is sufficient evidence supporting this agreement for me to grant it. I find that the defendant has pleaded guilty voluntarily. She is mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there is sufficient evidence supporting her guilty plea to find you guilty, I am not going to find you guilty. Instead, I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that I'm going to sign. Make sure you do. If you fail, your probation can be revoked. I can then find you guilty and you can be punished up to 10 years in prison. Plus, you would be labeled a liar, a dishonest person for the rest of your life. You don't want that. And also, you're a mother. You have to set examples for your children, which include being honest so that your children learn to be honest, right? Okay.
Yes.
This is going to be for 2 years. And I don't see, there's no fine.
No fine.
Let me see, probation terms. I think there's something that needs to be done to report and inform immigration and naturalization about this. So, because I don't know if they would normally know about it, but they have, she's being, I'm sure supervised like all resident aliens in the United States by immigration. And they need to know about what the status is here, I think. Because they're not necessarily going to know. I don't think that's going to affect what anything they would do. But I was in the federal government for 20 years and we don't know everything that's going on out in the other jurisdictions and all the time, there's a lot we did know, but this could affect your immigration status. You have to know that in all fairness, but you're not found guilty. And that is one thing going for you. But fix this. Do better. See the probation office sign and you begin probation. Do you understand what has happened today? All right, thank you.
They do get months like that on probation. Citizens.
Scott, you have anything else? No? Matthew Smith, John, is that you?
Yeah, no, that's.
No, you're John West. You're not Matthew Smith at all.
No, no, Matthew Smith. He's in jail. This is a continuation of a hearing we started. And Kim had to get a transcript for us. We had it on Monday, but we needed to get her transcript to review it, which is what you have right there. So we're going to pick up where we left off.
You want to do Mr. Solomon first, Jenny? Just to, is that over? He's set for trial.
So at least I can tell people, I won't be able to try and run field for the seminar. Tell them to try, you know, want to see you. They won't be able to try.
Those three other cases.
Those guys.
Trying to show say stuff.
So people, you know, 27th, I guess, maybe,
No, it's not.
but he can be.
Okay, let's get Solomon, please. Ken, thank you.
What do you heard all the phone calls where he said, well, I've manipulated others for days.
Y'all got to refresh my memory on this one. Where are we on this?
Solomon?
Yes.
So.
All right, so we've,
This
it's
is
a pro se matter, Judge, where I've gotten involved in the written discovery. Had a study be brought over here today so that I can convey a final offer on the record to him. And if he rejects it, then I've got media discovery that
Is it
he needs to review.
this sexual assault of a child is what is primarily going to be
Yes, sir.
prosecuted.
Yes, sir.
Prostitution and online solicitation of.
It's all out of the same facts and circumstances. Yes, sir.
All right, you're Mr. Solomon.
Yes.
And we're here again. You have three cases, as you know, that we're dealing with, and the state has asked, we've set this for a hearing for the state to make sure, and the court is satisfied that you've received all the discovery that you need. You're going to continue to represent yourself. Is that what you want to do?
Correct, sir.
Okay. All right. And who's standby counsel? John West. Okay. So on the 22-39310 sexual assault of a child, a second degree felony, that's the case the state is going to proceed on first. And then you got the other two cases.
I will probably try them all at the same time, Judge.
Is that
They're
what
all
you
out.
want to do?
Yes, sir. They're all out of the same fact pattern. It's the aggravated sexual assault of a child, prostitution, and online solicitation. The state has previously filed a motion to consolidate, as well as giving notice that we intend to ask for the sentences to be stacked in the event of conviction.
All right.
So today, what I wanted to do, Your Honor, since is currently set on the July 20th docket, was really trying to make sure that we have everything that we need for Mr. Solomon. And since he's representing himself, I prefer to do that on the record. So I know that we conveyed previously, and we had you confirm about written discovery. I've got media discovery I'm going to go over with you. And it's
What are you going to do
represented.
that?
If he rejects the last offer I'm going to make to him today, Judge, I'm going to have him review these matters. I'm showing, since the record is silent, I'm showing him a media sheet that has 6 different matters that is represented is as to the media that's on this. One of those matters includes a report of cell phone evidence that constitutes a report that was provided by the officer that downloaded this information. It is approximately 180 pages. I'm tendering that to Solomon, who's copying, and initialing that for the record. That way you'll have an opportunity to look at. I don't know, he's had counsel previously where offers have been made, but I don't know what the status of that is. So formally for the record, I'm giving him an opportunity to take the matter, take a sentence of 10 years on the aggravated, the sexual assault of a child. I'll dismiss the remainder if he accepts that. If he doesn't, I'm prepared to proceed.
So how long does he have to consider that?
Well, I'm assuming that counsel previously, since that's been offered, has talked with him about it. So I prefer to get his answer today.
Nobody's ever talked to me about any offers.
That was what I was afraid of.
Nobody has ever, none of your lawyers, no lawyer has?
Would you like time to consider that?
Actually, no. I do want to go to trial.
All right, so we've got
Okay, hold on. So you feel like you've had enough time to reflect on what it could be, what you could be considered? Are you saying that you're rejecting that offer because that sends us to a trial? If you're not, I can give you a little time to think about it, but we're still going to move forward one way or the other. But
I understand.
but if you've thought about it enough that if you're resolved one way or the other.
I have had 4 years, 3 months.
Okay.
Detained in jail, and that is all I think about, and I'm determined to prove my innocence.
Okay. That's what we'll do.
so that the record's clear, the danger there of proceeding to trial, rejecting that offer is that each of these indictments are second-degree felonies. And with the state's prior notice on this matter, depending upon a jury's sentence and the court ruling that the matter can be stacked, his exposure is up to 60 years.
I think you know, sir.
I just want to make sure that it's clear for the record, Judge. So if he doesn't have a lawyer that's representing him.
I can object to that. I'm not quite sure of the laws.
Well, that's what the punishment ranges are for each of these cases that have been indicted under that section that they've indicted. But they still have to be found guilty beyond a reasonable doubt.
They do. And when the state actually gave these notices of that intent, when he had hired counsel, Mr. Gertz, all the way back in 23. But we also made those offers that he indicated today that he hadn't heard.
Okay.
Even when I had counsel, Mr. Gertz never sat with me, never counseled, we never went through my case at all, never.
So we now have the logistical problem of ensuring that he's had an opportunity to see this media, which is why I asked that he be here. So we'll work on trying to get all that resolved so that we can do that for the 20th, Judge. Starting with.
Well, hold on. You're saying so that we're getting the information to him today so that we can try this case on the 20th?
Yes, sir.
Okay. This month.
Yes, sir. It's the top one on the docket as of now, Judge.
Yeah. Okay. What do we do next?
Well, I need him to start reviewing this media.
How's that going to happen?
We've got him here so that we can get that started in the room now.
The jury room?
Yes, sir.
Okay.
I've got an investigator. I'll need to finish the hearing with Mr. West. but I can get him started as far as
Who's
that's
his
concerned.
standby? Mr.
John
West
West.
is? Okay.
So we may be delayed until that hearing gets started, but yeah, he
Okay.
can certainly start reviewing. And I'm giving him this physical, his own copy of the cell phone extraction.
Okay, anything else?
No, sir.
All right, let's get that done. Let's move forward. Thank you.
Would you be willing to sign this, sir?
Jimmy, give them this file back. He's.
We're gonna let him review
We may have to scramble for a couple witnesses, because it's brand new people who are going to go now, because not doing most of our witnesses, my according to it's all basically. I'm gonna get these all lined up, not saved. Okay. I'm getting so, okay, yes, that. Yeah, do you think, I gotta get these tied up now.
If you'll give me a moment, I can probably get him started.
Yeah. Yes, we can get him in there. He can take whatever time he needs to read that. We've got this other matter we've got to do. Thank you.
That's the sound. Exactly. I'll just.
Matthew Smith is next.
Yes, Judge.
All right, what are we doing here with Mr. Smith's case? Who's the,
Jimmy.
Mr. Tran, honorable one, he stepped out.
And John.
Matthew.
Continuation.
yeah, just have a seat right there next to John West, your attorney. Thank you, sir.
Judge, can I approach on one of my clients from earlier?
What?
Antonio Landrio, there was a question about switching him to a drug patch versus having him on a GPS monitor. He did pass his drug test in court today. I didn't know if that was something that we wanted to send to his bonds people to have that switched to a drug patch.
Yeah, I want him on a drug patch. I'd rather him on that one
Okay. On Antonio Landrio.
than a GPS.
Oh, okay. So we're
But
switching.
we got him on, we caught him on the drug, so that's. Yeah.
Yes.
Someone was filling in for us on that memo, and I think that was someone mistakes. But okay, we're gonna fix it.
Okay, that's all I have, Judge. Thank you.
Are we ready on Mr. Smith?
We are. Yes.
We're gonna send that.
Okay,
Thank
we,
you.
We're gonna do.
now, we call clause number 24, CR 2405. The state of Texas versus Matthew Allen Smith. Mr. Smith has been on probation in this court since June 24th of 2025. A motion to revoke unadjudicated probation has been filed in this case as of October 17th of last year, 2025. And that's why we are here. We're kind of picking up where we had left off,
According to the transcript.
and I can't remember where we left off.
According to the transcript, Your Honor, we have presented all of our evidence as to the conditions that alleged that he had violated. When we went to the point of the defense presenting the case, is when the issue came up about whether or not he may or may not have understood and dealt with the mental competency issue. At that stage, whenever I had asked that That we'd be
Oh.
allowed to do it just like we were prepared to do today, where we could pick up with all the methods that have been previously testified.
Okay. Any more? I think I'm gonna have one more. All right, this is a proceeding following up a hearing that was held January 21st of this year involving the defendant Matthew Allen Smith in this cause number 24 CR 2405. We began the hearing on the motion to revoke unadjudicated probation in this case that was filed in October of 2025. And because of those proceedings, someone came forward who is identified in by the court reporter in the transcript of that hearing that we did not complete. An unidentified lady who apparently is your mom. Came forth in that hearing and apparently wanted to be heard. And the court had decided in the course of that hearing that there was indications presented in the hearing where the defendant might be incompetent to move forward with his legal proceedings because of issues that arose in that regard. And an abundance of caution, the court requested Dr. Ed Griffon, licensed psychiatrist, to evaluate the defendant for competency. He did that, and the court received his report dated May 29th, 2026, where Dr. Griffon deemed the defendant to be competent to stand trial. And we are going to refer to this as court's exhibit number 1 on this date. In this cause number 2405. But again, the substances of the defendant is competent to proceed with the resolvement of his legal issues in this case. Okay, so go ahead.
Matthew Smith.
Come forward and take a seat here, sir. And before we proceed, I think we went over this, but I want to make sure for the record that it is clear. You are Matthew Allen Smith.
Yes, sir.
Who is the defendant in this case, sir? And raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. This motion to revoke unadjudicated probation, among other things, states that on June 24th, 2025, in this criminal district court, Jefferson County, Texas, you were placed on deferred or unadjudicated probation for a term of 10 years for the third degree felony of injury to a elderly individual age 65 years or older. Is that true and correct, sir?
No, sir, I didn't.
No. Were you placed on probation for that?
Yes, sir.
Okay, which meant you had pleaded guilty earlier, and there was an agreement to place you on deferred or unadjudicated probation, correct?
I was there, but I didn't touch him. He beat me.
No, we're gonna get to all of that. Did you plead guilty to that offense when we placed you on probation?
He told me I was there and so that I was guilty.
I'm sorry.
I told you.
Oh, hold on.
Okay.
Yeah, once again.
Go home, Mama. We need to talk to my mother. The police were paid money to take me to jail. I'm still hurt. I still can't walk here. I've been to the hospital twice, had 2 surgeries, and I'm missing parts in my eye. My dad took my eyeball out of my head and held it hostage and then squished it, and my eye squished on the inside, left right side of my left eye. And I'm missing a bunch of parts in there. He took them out with his fingers. He messed up my nose, was raping me. And he took out I went to the dentist and he went in there and paid them to get in there and he drilled through my tooth all the way up to the skull.
All right, I'm gonna ask the bailiff, don't interrupt when I speak. Okay, you're gonna have a fair opportunity to speak. I'm going to show you an item that is part of the record in this case called the written plea admonishments. Please look at that, sir, review it. And I'm going to ask you, did you sign that? I witnessed you doing that. Did you sign that document?
This is what I signed before I left the courtroom.
Yes.
He just told me to sign this.
Did you sign it?
Yes, sir.
All right. Is everything true and correct there? That's what you signed, that it was true and correct. But does that refresh your memory that you pleaded guilty in this court earlier to this offense and you were placed on probation on June 24th, 2025 as part of an agreement that was reached between you, your attorney, and the state of Texas?
I'm not guilty.
Did you sign
I
that?
signed the paper, yes, sir.
Okay, thank you. All right, and based upon this agreement, the court placed the defendant on probation for 7 years. And then this subsequent to that, which was on or about June 23rd of 2025. Stand up. Actually, this states that the probation length was actually 10 years. Can you? But the motion to revoke states the defendant was placed on a period of 10 years. But let's see. Okay.
Judge, that's correct. It's a 10-year term.
Let's see. There was an agreed an agreement that was reached, and then there was a non-binding request of 7 years probation. The court, though that was non-binding to the court did follow the agreement by placing the defendant on deferred or unadjudicated probation as of June 23rd of 2025 last year for this crime of injury to an elderly individual, a person 65 years of age or older. And the defendant was placed on 10 years deferred or unadjudicated probation on that date, June 23rd, 2025. And the motion alleges 7 violations. 1, that the defendant failed to avoid injurious or vicious habits as directed by the court by testing positive for tetrahydrocannabinol on or about September 29th, 2025, in violation of condition 2 of his deferred or unadjudicated order. He provided a urine sample on or about September 29th that day, which showed the presence of tetrahydrocannabinol or marijuana in his system. 3, he failed to provide verification of attending rehabilitation treatment, residential programs, and counseling as directed by the probation office in violation of condition 12 of his deferred or unadjudicated probation order. 4, failed to provide verification of performing community service hours as required and as directed by the court in violation of condition 17 of his deferred adjudication order. And 5, failed to provide verification of entering and successfully completing the anger management program as directed by the probation office in violation of condition 26 of his deferred or unadjudicated probation order. Violation 6, had contact with the victim of this crime, which was a violation of condition 27 of his deferred or unadjudicated probation order, which states do not contact the victim. And 7, failed to pay court assessed fee as directed. As of September 29th, 2025, the defendant was in arrears $400 in violation of condition 35 of his deferred or unadjudicated probation order. Court will note that this motion to revoke probation was filed on October 17th, 2025, which was less than 4 months after the defendant was placed on probation. And again, is facing 7 alleged violations of his probation order. Okay, I think the record has been clear on certain matters, and the state had rested its case in this motion to revoke probation. And Mr. West, on behalf of the defendant, you may go forward.
Thank you, Your Honor. All right, Matthew, there's 7, like the judge just said, there's 7 different violations regarding your probation that the state's trying to prove that you violated and did not live up to your probation. You understand that, correct?
Yes, sir. I tried to go to probation right when I got home because told me to tell to call the police or get contact with anyone that I could about getting in here for the trial.
Right.
I needed to go to my mom and talk to her about it because I don't know exactly what all had happened. And then I heard the police information hit me up in the home. So when I went there, she told me that
Hold on. Hold on. Let me ask you questions, okay? Let me walk you through this, okay? You want to get a bunch of stuff out, let's go through each one, okay? The reason we're here today is that there's 7 violations they're claiming, okay? So I'm saying, let's go through each one of the violations, okay? It's not regarding what all happened, all that, and everything. It's just these violations. The first violation, actually the first 2 kind of go together, is that they're alleging back in September of 25, September 29th, 2025, that you used THC or marijuana. Were you smoking marijuana back then?
Legal stuff at the store. I don't know. It's fake.
Okay. So the question is, were you smoking marijuana at the time?
I don't know that it's not marijuana. It's just fake.
Okay. Okay. So you're using some substance, you don't know what it was, what you're saying.
It's at the stores. You know, they sell it every day at the stores.
Okay. Okay. So so if THC was in your system, it's through legal substances, is what you're saying, correct?
That's what I'm.
Okay. All right. Another allegation is that you do not provide verification of attending rehabilitation treatment, residential programs, and counseling as directed. Were you told to go into any kind of programs or anything like that?
No, sir, what happened was I was driven up there, and then when they were gonna try to show me a video, they said they would do it another time. And I was like, okay, and then, well, when I was in there, my mom was like, she left, and then I was supposed to be able to do something, but when I was in there, my knee was all messed up, I couldn't walk home, I couldn't get a hold of my mom. They were like, okay, well, we'll just talk to you about it another time. So I ended up having to walk all the way home. But like really far and everything, and they said they didn't want to set up the room or something like that or whatever, and
Okay.
I don't know if I'm looking
So
at
you-
video or whatever.
So you were trying to do all the programs they were giving you, correct?
Yes, sir.
Okay. And you believe you did everything they asked you to do as far as any kind of programs? Okay. Now, verification of community service. Did you do any community service?
No, so I didn't do anything wrong at all.
No,
I
community.
tell you all, I was raped and beat down.
Okay.
The police were paid to take me to.
Okay, hold on, Mr. You're getting off topic, okay? That's not what we're talking about right now. We're talking about community service. One of the allegations they're making is that you did not do your community service. Had you done any community service at that point?
No, I'm not doing any community service. I was the one that was beat down.
Okay, so you're not gonna do any of the community service?
No, never.
Okay.
I'm the one that was hurt. I'm the big.
Okay.
When we can
The
take
next one-
we can show them missing body parts in the skull right.
Okay. The next one is that they're alleging you continue to reside with the victim or the complaining the victim in the case, Craig Copeland. At the time that you were on probation, were you still living with Craig Copeland?
He won't leave my house, and mom has my money, and I don't have anywhere to go anywhere.
That was a yes or no. Then you can explain it.
Yeah. Just answer yes, and I'll ask you. Do you?
He's living in my house right now.
Okay, all right. And you say it's your house. Who you own the house?
Mom lives.
Your mom owns the house. Okay. And she's letting him live there.
Yes, sir.
Okay. And you're living there as well.
Yes, sir.
Okay. Why aren't you living with your mother?
Mom is living there.
Okay, your mother and the father and you are all living in the same
Yes,
place.
sir.
Okay.
My mom has my money, so I can't go anywhere else. I don't have any option to do anything. I don't have any choices or anything like that.
All right. So
Again, sir,
I don't have any options or choices to go anywhere else. I'm crippled now, and my mom has kept my money from me. And I don't have any desire to go live in a little apartment. I tried before, and then he comes in there and he beats me up, and he pays people to come in there and hurt me.
who does that?
My father, his name is Craig Copeland.
okay. But the beginning, back to what I'm saying.
You're
is
talking
that-
about the person who is the alleged victim in this case
Yes, sir.
that you pleaded guilty to.
Yes, sir.
Okay, go ahead.
My point is that you receive disability benefits, is that correct?
Yes, sir.
Okay. So you get a check every month, correct?
Yes, sir.
Okay. But your mother gets that money.
That's correct.
Okay. She has power of attorney or something like that.
Yes, sir.
Okay. And what does she do with the money?
Well, I mean, she's gone with her. That's all I know. I haven't been able to do anything since it happened.
Okay.
It was like, when I first got on there, I started doing some things. I had a whole bunch of cool jobs, did a whole bunch of things. But then she kept on making it for money to go to like
Sir,
somewhere else.
not to interrupt you, but what kind of jobs did you have?
I worked here, worked
What do you mean here?
like in this building,
Oh, really? What did you do here,
all stuff that I could, I
sir?
did stuff back there. I did.
Was it maintenance work or
It was,
cleaning up or
it
what?
was, I don't know, can you not look it up or anything? It was anything really. I mean, I had a job at the jail and, keep working there and everything as a guard.
Okay, is this while you're in custody? While you're in custody, it was when you were free, in the free world?
Yes, sir.
You were, but what did you do up here at the courthourse? I don't understand.
I worked back there for a little
When
while.
you're pointing, what's back there?
Right, like, where
That's
the-
my
those
office.
People come up in here. Right back here, right
Okay,
behind me for.
What were you, what did you do for work?
So people come up and through here, to here.
And then what? I know people are coming up. That doesn't make any sense. What were you doing? Were you cleaning up or painting or something? What?
I was like working here. I was like telling people to come in, out. It's in the last 6 years. It may
Anybody-
be for a little while. It's not very long, but it.
No, but what things did you do? Tell me, description. What was the work that you were doing? You said here.
Well, yes.
What is it? What were you actually doing? Painting or fixing things or what?
Fixing things probably, I don't remember, it wasn't really that long ago. I was working over at the other building and tried, when I got my jacket sent to me, it got sent to my sister, my sister took it from the.
What was, you speak so quickly, you speak real fast. I know you're thinking real fast. What about your sister?
Okay, there was a court session about it where I tried to receive my jacket.
Your jacket, like a coat jacket?
Yeah,
Okay, all right.
Underwear, and someone took it, and when I went to go receive it, they were like, "Yes, come on in, and you can talk." There's another guard, okay, but then what she did is she put my jacket inside of her closet, and when I was going to leave, it wasn't there, so I called the police, and then they were saying that somebody else took it, but that's what happened. So then I was like, they were kind of expensive, like almost $100 or something, so I couldn't even afford to want to buy another one. She tried to tell me to take off with her, but it smelled like a girl and everything. And so I was like, I can't really want to do that because it's weird, you know? And so then I stopped working really.
Okay, ask your next question, John. Thank you.
Right. So the point is, what I'm trying to get at is that the only income you have is through your disability checks that your mother gets, correct?
Yes, sir.
Okay. So you have no income or any source of funding to pay for any other place to live, correct?
No, sir.
Okay. So the only place you have to live is at your mother's house, correct?
Yes, sir.
Okay. And that happens to be also the place that your father lives.
Yes, sir.
Okay. And you say it's your mother's house. Does she own it or they own it together?
He doesn't have anything. He's just squatting there. Basically, he stinks. He doesn't shower.
Okay. That's not what I asked. Just hold on.
Had it built.
Are your mother and father divorced?
Yes, sir.
Okay. All right. But she's letting him live there and you live there both, correct?
Yes, sir.
Okay. So you got nowhere to go, right?
Right.
Okay. All right.
Are they letting you live there?
Yes, sir.
Well, that's where you go to live, right?
Yes, sir.
Right.
Oh.
That's my point, Your Honor, is that he's got nowhere else to go and the mother lets both of them live there.
Place. He's got no other place, I guess,
Right.
that he can think of or that he's planned for, but he has a home that's he's allowed to stay in.
And this line of questioning also goes to the next thing is that you're behind on paying some of your fines, fees, and stuff like that. Again, you have no access to your money, correct?
Yes, sir.
Okay. And your mother's not paying this for you, is she? Okay. So you've paid everything if you could pay, you would, correct?
Yes, sir.
Okay. But you have no access to any of this money.
Yes, sir.
Okay. All right. So you were trying to do everything you could on probation, correct?
Yes, sir.
Okay.
Hold
Except
on
the
for a
community.
second. Let me on that last one. Because it's a defense if you're not paying as required, but you are unable to for good reasons.
Yeah.
Where is the money located? Is it at a bank or something?
Yes, sir.
Okay, but it's not in your name?
No, sir.
Okay, so you can't go and write a check for it on your own or go to the bank and say, here I am, I'm Matthew Smith and I'm here to get my money from the bank account. You can't do that.
No.
Okay. All right. Why is it that way? Why don't you have your own independent bank account?
When I was went in there, the Social Security office, the woman was disrespectful when when we were about to walk off. She said something about, is he on the mailing address? And I said, yes. And I emailed it. And she said, oh, well, let me just put her name on the front of the check. Also, and so that we'll make sure that it comes there. She need to learn to start passing them. And I said, no, that's not going to work for me. She said, oh, I already started typing. And ever since then, my life has been hell.
Is your income exclusively Social Security?
Yes, sir.
Okay, why you're obviously not at retirement age. Why are you getting Social Security?
Disability.
I'm just curious what he's going to say.
Okay.
Why are you getting Social Security?
When I was young, My dad had me abducted. He had me beat up and I sat here and I've been on a pretty good system. He's also.
It's a disability type payment?
I completely can't even read good right now. It's been ever since I was 7. Like I'm scared. I woke up this morning, my whole left side of my head, it feels like it's going numb.
Okay, but it's social security by disability. Is that what it is, John? That's what you understand?
That's what I
He
understand.
was declared disabled, physically or otherwise, and then so the government sends him a check every month. Do you know how much you're getting a month?
Not exactly. There's all been controversy about it. As a matter of fact, the check was split. You know, a lot of it was sent through maybe like split in half. And it was sent to my grandparents' house for several years. And my grandfather received the money somehow and was able to cash it. And he hasn't given me the money at all. And he basically blown me off. And so, I mean, by now I could have already bought a house and lived in this, have children and everything. And
You have children?
yes, sir.
How many?
I just had at least one, but
Wait a second. I know exactly how many children I have. You know, it's not at least.
Well, you didn't have your money right, you weren't allowed to go anywhere.
No, your children. You
That's
know how
bad.
many children you have.
I'm telling you, sir, I'm trying to tell you something. I have a daughter. Thing is, she has kids that look like me, so I don't know if they're mine or something.
Oh, that's what you're saying.
I'm not a bad person or anything, it's just, you know, there's.
Were you married to the lady? Were you married to the lady?
I was married to baby's mother, but she's really wild, and she went off right after we had a kid. And she went over towards her parents' house, and they didn't do anything right for us. And then I tried to go over to my grandparents' house with my daughter, and then mom took over, and my mom moved over to another Plano for a while, and then the daughter grew up a little bit. And
How old is your daughter?
The daughter's about 27 or 28.
Oh, really? You have somebody almost 30 years of age, a child?
Yes.
Really?
Last.
You're 47?
Yes, sir.
Go ahead, John. Sorry.
Oh, it's okay.
I'm just clearing some things up here.
Okay. So what I'm getting at is you were trying to cooperate with the probation department as best you could, correct?
Yes, sir.
Okay. And as far as community service, you said you're completely disabled, correct?
Yes, sir.
Okay. So you weren't able to do any of the community service, right? Okay. You weren't able to make any payments because you don't get any of the money, correct? Okay. And as far as the THC, the only thing you can think of is that maybe there's some of the legal sources where you took something from a gas station or something like that.
Yes, sir.
Okay. At some point, I think the probation officer said you told him you weren't going to stop using drugs. Do you ever remember telling him that?
I don't do drugs. There's that stuff that's legalized, and it's just all it does is calm down.
Okay. That's witness.
Next.
I have no questions of the witness, Jeff.
Nothing further, Your Honor.
Okay. All right. You may be seated, sir.
Defense rest, Your Honor.
Defense arrest, what says the state? Any further evidence to be presented by either party?
No, Your Honor, going back through the record, I'm not sure that it officially showed that I rested whenever we were conducting the matters back in January, but I do officially rest. I don't have any additional witnesses.
All right. Okay, then parties are invited to summarize their arguments and what they are requesting. State may go first and end.
Judge, I think the evidence specifically from Mr. Hill's testimony back in January is that it is it's proof that he is in violation of his probation.
And you're talking about from the probation officer.
Yes, sir. And it's actually it's
In what regards? I mean, once again, we have 7 allegations of violations. If you could summarize which ones, if not all of them, that you were requesting the court affirmatively act upon as violations.
all of them, Judge.
What about the money? For example,
I don't,
pay,
no,
uh,
I'm not concerned about money.
the defendant states he's unable to pay because he doesn't have access to it.
I'll abandon the money, Judge.
Okay.
It's never a concern for
So-
this particular attorney.
All right, so Mr. Smith, on that one, the state is abandoning that. It's going to be allegation 7.
My summation is that Mr. Smith is his own worst enemy. He's doing everything he can to prevent us from helping him. The whole goal for this probation at the time in which this offense occurred was to get him supervised. And they've done everything they could to try to do a mental evaluation so that we can move forward. He is competent, but he's got some mental health issues. That's clear. And Your Honor knows the legal distinction between those things. And if you won't cooperate with the probation officer for us to get the evaluation, how are we supposed to treat him? That's problem 1. Problem 2 is he's obviously making his situation worse with his drug use, which he refuses to change and has quite an attitude about that. So if he's going to tie our hands and he's not going to let us make those matters happen, then it's going to force me to ask you to consider putting him in prison. I don't want to do that. I'd like for him to do the evaluation. I'd love for us to try to give this man some assistance. But then the whole reason why we're here having this hearing is it's probably going to take court intervention for us to get that. And we've done what we can before we got here. That's my position, Judge.
Mr. West, on behalf of the defense.
Thank you, Your Honor. I think it's probably one of the first times ever I've been in a hearing, and I agree with Mr. Ham completely. This is something where we need to make sure you write that down.
I want a copy of that.
It comes down to that he needs help, Your Honor, and he's found competent, but we all agree that there's some issues here. We need to figure out some way to get this guy some help here. As far as paying the money that's been abandoned, that also goes in the fact that he doesn't have a place to live because he can't afford a place to live. His mother's getting all the money. What's happening there, I don't know. But she's apparently giving him a place to live, so she may be using it to provide all the needs that he needs living there. I'm not saying she's taking the money improperly or whatever. I think she's probably using that to provide for the utilities and the bills and the food and all those kind of things.
Which one?
This,
Yeah, just turn it a little bit.
Yes,
that way,
Oh,
We're looking at vacant jury box.
sorry.
A little more. There we go. Thank you. And good. Perfect. Thank you. Go ahead.
as far as the drug use, Your Honor, I think that goes into his mental issues as well. I think he's using stuff that he believes is legal to cope with his I don't want to say the voices in his head, but things that are going on in his mind. Community service, I don't think he can do community service. I think there needs to be some kind of way to work around that. I don't think he's able to do that. He doesn't have a good grasp of what's going on. I mean, you just heard him talk about he worked up here at the courthouse and worked at the jail. I don't think he's doing that. I think he has these ideas in his head. This comes down to a situation where we need to get this guy some help, some type of help. That's all we can do. We can send him to prison. It's an option. Or easily do that, but what is that going to do? He's going to get out in 2, 3, 4, 5 years and back to have these same kind of ideas. So I'm just looking forward to figure out what to do in this case.
Anything from the state? More.
It's that attitude issue I talked about with Mr. Copeland with your copy of the transcript. If you look at page 13 from that prior hearing, when Mr. Hill was talking about him testing positive for THC, he quoted the defendant said, "I will not stop using drugs." And that's like I said, that just underlining what we're dealing with here. And I think he's, as I said, it's a combination of all those factors we've already discussed.
Well, what are you asking?
Like I said, it's time in my hands where I have to ask for you to put him in prison. I don't want to do that. I want him to get the evaluation done and for us to work with him. But if we can't get him to do that, then I need him to go to prison.
Okay. And finally, Mr. Smith, this is all about you, really. You're the focus. Is there anything else you would like to say?
My dad beat me and raped me and hurt. And when I got picked up by the police, they came and took me out of my home. And I tried to tell them what happened. And they wouldn't listen to me. They said, shut up, we're making money right now. So then when I went to the jail for 2 months, I was hurt the whole time. I went to the hospital and had surgery. It's not fixing. My dad literally stomped my leg. I tried to go lay down in my bed. And then I got up, the police were there. And then they were paid thousands of dollars to take me to jail.
Wait.
Anything to break open at
Who
all.
paid you? Who paid the police?
By people's hands.
Let me ask a question. Don't interrupt because she can't take everything down when two people are speaking at one time, okay? All right. My question is, who is it that you say paid the police thousands of dollars to act illegally against you? Who?
They were in the front room. My mom and dad were there.
Who?
My mom and dad were there.
Is that who you're talking about?
Yes, sir.
Okay. So it was a conspiracy hatched by your parents.
Not conspiracy, they took money.
They worked together.
Ask the police to pick me up, they'll tell you they took dollars.
And you saw your parents pay the police cash money.
And I heard them say, my dad said, how about a bribe? And then all of a sudden, I was like, let me come out there and show you what happened. And
Wait.
Just stay right there.
They were speaking to the police?
Yes, sir.
All right. Well, the police.
It's illegal, so let's get on this, please.
The police, like everyone else charged with a crime, are presumed innocent unless proven guilty. And in this case, there has been no proof other than your statements that the police have done anything wrong. However, once again, Mr. Interrupter, let me finish speaking before you take over like you do all the time. Let me speak and you have a fair opportunity. What we call that is fairness. That's what we do in this room, act fairly. Now, you're butting in and bullying but you get a fair opportunity. In this case, we went over this thoroughly. You pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. You signed documents stating that you understood your rights and you were making this decision to plead guilty voluntarily, knowingly, intelligently. And there's your signature. You signed the plea papers, the written plea documents. You signed it at least two places on these documents that you were giving up your rights to a jury trial and the rights to the confrontation and cross-examinations of witnesses. You are guilty of the offense and any lesser included offenses charged against you. And here's the favorite part that's always in there that people sign. You swore that all of that was true and correct, so help you God, just like the oath you took today. So based upon the agreement that had been reached between you and your attorney, the state, the court followed the agreement and placed you on deferred or unadjudicated probation last year, where you were not found guilty. And your record was clear. However, it wasn't but a few months that went by that you are alleged to have tested positive for tetrahydrocannabinol THC. You provided a urine sample that also tested positive for THC drugs. You failed to provide verification of attending the rehabilitation, treatment, and residential programs and counseling as directed. You failed to provide verification of performing any community service hours as directed. You failed to provide verification of entering and successfully completing an important prospect, the anger management program as directed. And you had contact with the victim. You were not supposed to have contact with him unless otherwise allowed by the court. And this was either in person, by telephone, or through a third party in violation of condition of your deferred adjudication order. What the court is finding that you have violated allegations 1, 2, 3, 4, 5, and 6, the allegations as alleged in this motion to revoke unadjudicated probation, and the court finds true those allegations have been proven by a preponderance of the evidence or greater. And thus, because of all of that, the court is going to grant this motion to revoke unadjudicated probation, and your unadjudicated or deferred probation is hereby revoked. Earlier in this case, you pleaded guilty to the offense of the third-degree felony of injury to an elderly person. You pleaded guilty voluntarily. You were mentally competent to do so, as you have been deemed mentally competent by Dr. Ed Grappon, by his recent evaluation of you, and you were mentally competent to proceed with the hearing on this matter. There was sufficient evidence at your plea hearing from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you competent in this case, and I also find that you are now declared guilty beyond a reasonable doubt of the underlying offense here of this third-degree felony of injury to an elderly person. And you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. But I am going to suspend that and give you another chance. I'm going to place you on regular probation. You have been in custody for almost a year. I'm going to put you on regular probation for 9 years. Follow these terms and conditions of probation that you failed, including the ones you failed to. You're going to be placed on orders of probation, and they will include conditions to also help you with your issues that we all hear coming out of your mouth when you express statements. And Dr. Ed Grappon is one of the finest psychiatrists in the land, and he knows how you act and how you answered questions, and he declared you competent nonetheless. I trust that what we have here is some issues that you need to address that don't rise to the level of incompetency or insanity, but still are issues that need to be addressed to help you complete your probation without revocation. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison. And you've already gotten about a year of this, but still you don't want another day in prison, do you? You want to be a free man. I'm sure we all do. But you've got to follow these conditions, and the conditions will include the similar conditions that you failed on. Don't use drugs unless you, any controlled substance unless otherwise allowed by the courts. Make sure that you attend your meetings with the probation office. And I want some kind of program from the probation office that can help him regularly touch base with guidance on his independent living, because I get the feeling that living with his parents does not work well. There's apparently they disagree on the way life should be in the household. And first of all, unless you own that house, it's their house, their home. I don't know, maybe you own the house. If you do, then that you have the rights and privileges to declare who should be in the home. But I don't think that's true. I think your parents own that home. You may need to seek out some kind of an independent life for your own at another location, another habitation. But you can't have any contact with the victim unless ordered by the court. And the victim in this case is Craig Copeland, who is your father, right?
Yes, sir.
Okay. Unless Mr. Copeland decides otherwise. But what I've heard here on the witness stand is a lot of antagonism between the defendant and what goes on in that home and the family. And I wish the family was a unit. I mean, I think it's important. Family is sacred. You didn't get to pick out your family. The creator did. There's always a master plan afoot. And we don't know why that happens, but it's the way nature intended. And most people seem to get along with their family and enjoy a familial relationship that is a customary one of love and appreciation and respect. Whatever is happening in your household is not working that way. You're entitled to live happily. The pursuit of happiness is in the Constitution, but you need to, and the Declaration of Independence. But you need to seek that out without harming others and without a disobeyance of the probation requirements that you're going to be required to live under. There are 35 conditions of probation here. Most of these are conditions all of us in this room have to follow. We're beginning with 1, don't commit an offense. That's what we all must do, or else we get in trouble. 2, avoid injurious or vicious habits. All of us should be doing that. Don't associate with disreputable people. All of it should be done. And it goes on and on. It's a blueprint for proper behavior. And if you fail, you'll be back in front of this court, and the court can consider revoking your probation and sentencing you to prison, which I'd rather not do. I'd rather you go out and live a happy, independent life without trouble, without problems, and be happy, not unhappy. Only you can figure out what makes you happy or not. But you also are free to make the wrong decisions as well as the correct decisions. Correct decisions reward you, wrong decisions punish, and that's for all of us. If I follow through and sign this order of probation, do you promise you will do your best to follow these terms and conditions of probation?
Yes, sir.
All right, do your best. What do you intend to do about living? Where would you live?
I'll have my money. Mom has all of my money.
Okay. All right, John, as his attorney, can you figure out what is actually financial means he is entitled to. And the court can make orders if necessary to enforce that. But I want it verified before I start signing anything. And we could have a hearing on it, and they could be required to come up and show proof, and he's got the, I mean, they're presumed innocent too, so
Right.
the burden of proof is going to be on the asserting party, him. But if it's his, he's entitled to it, and he's declared competent, and he shouldn't be kept away from it. And if we're competent, we're all entitled to frivolously misuse it, which isn't the smartest thing to do, of course. But he's competent, and like most of the people, and he is going to be allowed to make his choices, right or wrong, and live with them, right or wrong. All right. We also need some kind of a plan for continuous maintenance on the emotional or mental. Even though he's competent, that doesn't mean he's perfect. And whatever we can do to help him become the best he can be in his independence and choice making is what we want to do. Any thoughts?
I'm gonna place him on the mental health initiative caseload.
All right, that's good. That's good. That doesn't mean you're going to go to any kind of a facility, or you're going to be independent. You're going to make your own choices, make wise choices. Don't come back here, and you come back here for a violation of probation, and you're looking at prison. And that includes staying away from illegal drugs. Do you understand? Because they're going to test you from time to time.
Yes,
And
sir.
you
So-
test positive, and you'll come right back here, and we'll have to deal with it.
So it's not illegal, then it's okay?
Yeah, but you better be correct in your choice making.
So I
If
can't
it's
smoke.
tetrahydrocannabinol, I'm not granting it.
Just say no, Judge, because he's thinking that he can smoke marijuana.
It's that stuff that you can buy from the vape stores and the gas stations. Yeah,
What's coming? Well, you're testing for tetrahydrocannabinol.
correct, and it's gonna test positive for that.
Yeah, if it tests positive, for tetrahydrocannabinol, shame on you. You know what? Try something else. You know what I do? I'm addicted to Italian sausage. All right, not to make light of it, but find something else that your system enjoys. Anything else? That is all. We are in recess. Thank you.
Imagine walking into court believing your case could finally disappear, only to discover that every decision you make that day could affect your future for years. That's exactly what happened during this courtroom hearing. The defendant appeared without an attorney, hoping to resolve a misdemeanor case as quickly as possible. Before the hearing even began, the prosecutor presented an offer that sounded almost too good to pass up: a 12-month deferred judgment of conviction. Under that agreement, the defendant would complete a drug and alcohol assessment, follow any recommended treatment, stay out of legal trouble for 1 year, and if every condition was met, the entire case would eventually be dismissed. Hearing those words, the defendant immediately wanted to accept the offer. But the judge wasn't willing to let such an important decision be made without fully understanding the consequences. The judge carefully slowed everything down. She explained that a deferred judgment isn't the same as having charges immediately dismissed. Instead, it works like a legal contract between the defendant and the court. For the next 12 months, the charge would remain hanging over the defendant's head. If the defendant completed every condition, avoided new criminal charges, and successfully finished treatment, the case could be dismissed at the end of the agreement. But if any condition was violated, the court could enter a conviction without the benefit of a trial. Although the defendant repeatedly said, "I'll take it," the judge refused to